stay hydrated. So all of take heed too. All right. So today we're going to do Unit 4, but before we begin Unit 4, she's not on. Demetria is. Demetria, you want to do Stubbs versus Crawford?
Could you come back to me, please? Please. This is so long. Yeah, please come back to me.
Okay. If not tonight, we could do it next week, but you're gonna have more cases next week.
That's fine.
Okay. Who is ready? Cleopatra? She isn't on. So let's see. Xenia? Mackenzie? Oh, she's not back to the phone as yet. And Cleopatra isn't here. Wonder where Mackenzie went.
If you want, I guess we could talk through this agreement of sale.
Okay, all right. Stubbs versus Crawford.
No, this was Litza Marling Sugary Silver, who was the plaintiff, and we played Destination.
Yeah, okay.
Boy, this was extremely long and eye-tiring.
Yeah. They're long, like Miss Archer. I guess we can go through Stubbs v. Crawford after Dorame is done.
Yeah, we could.
Okay.
So, like, I try to summarize this, and I don't even know if that worked, but the gist of this case was the plaintiff was trying to buy a unit, a condo unit, and within the agreement of sale time period, some stuff wasn't happening the way she thought it should happen, and she wanted to pull out of the sale. So the introduction to this is, as noted, at the heart of this dispute, in a discrepancy of some 1,300 square feet, it is the approximate difference in the size of a luxury penthouse advertised for sale and in an exclusive condominium complex on Paradise Island called the One Ocean Condominium. After extensive renovations, the dimensions recorded in the statutory declaration containing the certified architectural drawings and plans of the building, the declaration, which was called the Declaration of Condominium. The discrepancy led the plaintiff, who was the purchaser, to rescind the agreement for sale over concerns that the defendant, Mr. Wender, was unable to convey good title to the unit and has resulted in the litigation. So, as we know, 30-year root title defines, or going back 30 years on a root title, this defines good and marketable title. But according to the Declaration of Condominium, that's not the case. And so They went to court, and according to the amendment of the declaration size and configuration of the complex, not the complex, of the unit that was supposed to be purchased, there was a discrepancy in the size. However, that wasn't noted in the sales agreement initially. So unit 901, which was the unit that was being purchased, was going under extensive renovation when the purchaser decided that she wanted to buy or went into the sales agreement to purchase. And it was advertising containing a square footage of 6,165 living space. However, the declaration registered under the Condominium Act described it as square footage comprising of 4,801 square feet. So there was a difference in the size. So the vendor then tried to come out of the agreement saying that the purchaser tried to come out of the agreement saying that the vendor failed to close on the date that was specified, failed to, I guess, have all the outstanding items that was set forth in the inspection statement, and delivering a temporary certificate of occupancy. So the purchaser then requires the vendor to forfeit to make good such as default by closing prior to the termination of the notice by completing all the outstanding matters set forth and providing a title insurance commitment, having met or having removed the requirement of completing by August. So they went into a further agreement or an extension of 14 days for the vendor to have all these items completed because they'd already missed the date. Otherwise, she would have wanted her deposit back. So this unit was being sold for $4,100,000. So she made a deposit of $410,000 on this. And if the vendor couldn't finish or complete all the items, she wanted her deposit back. So when it was on March 1st, because 2019, because 2018 August was when they were supposed to finish. The attorney representing the purchaser, which is King and Co., sent emails, among others, to the agent and the vendor and stakeholder, as well as the attorneys for One Ocean Homeowners Association. Email stated that the notice complete has expired at 5 o'clock and that the vendor had failed to complete, and in that they wanted to get a refund. So they went to court. Nacha, help me out if I skipping anything.
No, go ahead. You ain't get to the good part yet.
And so they went to court. Let's see here. I think I missed something. Okay, she wanted her deposit returned within 7 days after the notice.
Didn't they make some amendments?
The vendor, correct, the vendor was upset and he was like, well, no, because, you know, nothing was wrong and like we didn't reach the 14 days extension period yet. And so, why I need to get this money back. So apparently in the declaration, there was supposed to be some amendments prior to this new purchaser wanting to purchase unit 901. And apparently these amendments were never done. I was already on the path that, okay, she will win this case, but then make these amendments that they know far and well that needed to be amended from inception, because the roof on the building was destroyed and they needed to change it. And in changing it caused the square footage of the unit to be different.
Mm-hmm.
And so the declaration of agreement for sale dated the 19th of July 2018 entered between the plaintiff and the defendant is a valid and binding agreement, and the plaintiff is contractually bound to complete the purchase of Unit 901 at One Ocean Condominium, Paradise Island. The declaration that the plaintiff is stopped the issue of the unit entitlement due to clear terms and terms set out in the agreement for sale dated July 2018. In order that the plaintiff pay the defendant such damages associated by the delay and refusal to complete the said purchases, which was the amendments that they needed to have done.
Mm-hmm. But they did make some good points based upon what
They made
was
excellent
arguing.
points to face, because she was arguing that, the size ain't the same. They was advertising, something that wasn't really true. The defendant's arguments was valid as well, because I think in the sales agreement, if I could skip to that part, in the sales agreement, there was a part where the agreement was to only be altered by amendments in writing signed by both purchaser and sellers, except otherwise provided in the agreement. The entire agreement between the purchaser and seller must be expressed in writing. So it couldn't be nothing verbally. So even if she had gone to the unit and saw something and just verbally told the vendor, well, this ain't right and this ain't fixed, like, because she didn't put it in writing, it didn't stand.
But didn't the judge say that this case was like not the norm?
Yes. Yes, he actually had several points disputing the fact that, and I'll tell you what he said. He said, firstly, it was only illustrative rendition of the renovated model and not the actual plan of Unit 901 itself, which was 6,125 square footage, was also a difference from the architect findings, because the purchaser's attorney actually got a architect to go out and measure and gave a detailed description of the square footage for each area, which came back to an overall total, which was some 6,000 square footage as well, but it wasn't exact to the square footage that was actually being advertised for sale. And then he said the agreement provides for the vendor to sell and the purchaser to buy its free simple estate in possession in unit 901 together with the apparent, it was 2.06 unit entitlement in the common property of the unit. So they were talking about the common space,
Mm-hmm.
because the common spaces would have changed or it would have been enlarged based on the changes that they made to the roof of the building. And then the judge also went on to say that the purchasers specifically acknowledged that the title it was receiving would be subject to certain exceptions.
Yeah. You see at the very end when the judge made his observation and where he said that the act itself hasn't kept abreast with the mischief that could be caused with the provisions and the act itself.
Yes.
And he said, and it's being left to the courts. And he's saying that it's not the court's duty because the law hasn't kept pace right with the changes that is happening. And he gave a reference to what's happening with the law in Canada. Right. If the provision was put within the law, the purchaser would have had a leg to stand on.
Yes. Yes.
Because, right. So when he started, he spoke, you mentioned it. Yeah. When you started, you spoke about having good root title from a condominium point of view. That's paragraph 55 for everybody else, if you have it in front of you.
Yeah, sorry, because we had to skip through because this was a lot.
Yeah, but they can read it. Who didn't have a chance could read it over the holiday weekend. Have good reading with a glass of wine.
But it definitely was a good read, because initially I was like, she could win her case, but that wasn't the case, because at the end of the day the judge ended up ruling where she had to give the vendor time to finish. But he also made mention that because the vendor's star key witness took so long and they couldn't bring the evidence when they were supposed to, that they give us some 15% discount off the purchase.
Right. And then also when the judge said that even though time had passed, he was saying that the plaintiff still can raise issues.
Can raise issues, yes. Yes.
So this is a good one, especially for those who are interested in condominiums.
Condominiums, yes. And everything needs to be clear cut, nothing to be assumed.
Right.
At the end of the day, even though they had quarrels about what was in the actual declaration of condominium, didn't stand in court. It was actually what was in the agreement for
Agreement
sale
itself, yes. That's what the judge said. He said it's not that, it's the actual agreement. Because don't forget the agreement for sale, even though we're talking about land itself, and when you're talking about land straight out, you're talking about having a good and marketable title. But the agreement for sale, that document that you sign, is a contractual document.
Correct.
Right. So, and law is based on contract law. What was the agreement between the parties?
Yes. So while the declaration needed to be amended from inception, because they even went back where two other purchasers wanted to purchase 2 other units, and they found that the square footage was off from then, and they had this whole summons to have it changed and amended, which never happened. And the vendor agreed that it came to the forefront for them to have it amended, and it wasn't amended. And he was in the mind frame of having it done even at that point. But at the end of the day, because of the verbiage in the sales agreement and the client signed, the declaration didn't matter.
Yeah. But this is a good one. Especially for you all to learn in terms of when persons are getting mortgages and they start from agreement for sale, to see the distinction between the Law of Condominium Act and the Law of Conveyancing.
Yes, yes. If that's what the judge say, you have to go with the law.
Mm-hmm. Right?
The law
It says the
protects
title of the condominium property cannot be determined simply by reference to common law principles, because that's how you would do anything that's related to the law of conveyancing is based on common law principles.
common law.
Yeah. All right. Who wants to be next?
I can.
Okay.
Good evening. So the case that I have is against Finco. It was with Finco versus Philip Arlington Mitchell and Brenda May Mitchell. So a case was brought before the Supreme Court, the Common Law and Equity Division, in the matter of a mortgage and two further charges held by both parties, between both parties. So Finco being the mortgagee and the Mitchells being the mortgagers. Sorry. So it was also brought in the matter of the Mortgage Act, Chapter 156 of the revised laws. And this act makes provision with respect to the simplification in rules regarding redemption of foreclosure of mortgages. The rules concern satisfaction of cost by mortgager in actions concerning mortgages or ejections, and power of court to compel mortgagee to surrender premises, and legal proceedings regarding extinguishment of a mortgage. So basically, Finco took the Mitchells to court because for whatever reason, they were no longer making their mortgage payments with the bank. So in September 14, 2009, Finco, the plaintiff, began to present their case against the Mitchells, the defendants. Finco was seeking judgment with regards to payments that were due and owing under the mortgage between both parties. They also were seeking judgment on the order of vacant possession of the subject property, and also the declaration that the plaintiff was entitled to exercise a power of sale over the subject property. So Finco wanted the Mitchells to pay back the money owed. They wanted to evict them, and they wanted to formally place their home for sale, as it would now be deemed a foreclosure.
Can I interject? Can I interject?
Yes.
According to Mr. Mitchell, who appeared, without an attorney.
Yes, I was getting to that.
Yes, you need to say that.
I was getting to that.
Okay, all right, I'll let you get to it.
Okay. Okay, well, now you could say it, I guess.
No, you can say it. Go ahead.
Okay, so in April 15, 2014, the order of vacant possession was granted to Finco. But in May 20th, 2014, Mr. Mitchell filed a notice of appeal to the Court of Appeal, and in the interim was granted 90 days which delayed the order of vacant possession granted to Finco in April. So I was gonna say, going back to what you said, he was actually, well, when reading the whole case, he was, I want to say, I don't know if I should say intelligent, but
Go ahead.
this man, he came to court by himself. He didn't get a lawyer. He represented himself, and he fought teeth to teeth. But any way he could try to delay every appeal he made, he tried to delay every order that the court made against them. So in March in March 21st, 2018, the Court of Appeal dismissed Mr. Mitchell's appeal that was made in May, that was filed in May 20th, 2014. Then on April 9th, 2018, Mr. Mitchell then filed another notice of appeal seeking to leave to appeal the judicial to appeal to the Judicial Committee of the Privy Council and delay proceedings pending the outcome of this appeal. This application remains in existence as there was no evidence before the court as to the efforts made by the Mitchells to have the Privy Council motion heard. The Privy Council motion was filed 2 months shy of 3 years. So on January 23rd, 2020, by virtue of precipice, the bank applied to enforce the order of vacant possession. On April 14, 2020, a writ of possession was issued to FinCo. A writ of possession is an order for the court, from the court, which has previously made rulings in favor of, in this case, the mortgagee, which is FinCo, in an eviction case. The writ in this case directed the deputy provost marshal to seize and take control of the premises subject to the order and turn it over, in this case, to the mortgagee's possession. H&J, or Higgs and Johnson, the counsel for the bank, had notified the Mitchells via email and advised that same would be executed within 14 days following the cessation of the emergency orders that were in place due to COVID-19. So in July 2020, the deputy provost was instructed by the bank to hold off on the repossession overdue to the suspension of repossessions because of COVID-19 pandemic. So that was another delay because of COVID-19. The bank ceased for a while repossessing homes. At the end of the suspension period, the writ of possession was executed by the deputy provost marshal in January of 2021. The Mitchells were asked to vacate the home by February 2021. Now, Mr. Mitchell then filed the present application seeking to delay the proceedings again, pending the appeal to the Privy Council and to set aside the order of vacant possession together with the precipice and right of possession. So according to Mr. Mitchell, who appeared on his own, he pleaded with the court to grant his stay because, in his words, he and his family will be rendered homeless. They would lose their sacred and holy sanctuary. This is, and I quote, where they gathered to rest, pray, and give thanks to the heavenly creator. And they will face the predicaments of catching COVID-19 with the possibility of dying from it. So he going low. He therefore implored the court to grant him the stay pending the appeal of the Privy Council motive. So he claimed that he made so much claims. He also claimed that they should set aside same because there were new facts that had arisen since granting the order due to the issues of limitation and irregularities in form and procedure. This was untrue, as everything procedural was in his knowledge, in their knowledge, and made available to them from the time the proceedings began. So therefore, Mr. Mitchell's application was dismissed and he was to pay FinCo's cost of application to be taxed if not agreed. So going forward, the court would now become functus officio, meaning that they were no longer able to make any further rulings because a judgment or final order was already entered when the writ of possession had been granted to FinCo. Therefore, the relief sought by Mr. Mitchell to set aside the order for vacant possession was fundamentally flawed. So Mr. Mitchell had also claimed that there were irregularities with the precipice because there were no signatories on the communication. It was just a typed word that said Hicks and Johnson. But in fact, according to the court and recent cases, it was an accepted signature. In fact, the meaning of the word signed had evolved in such a way that it extended beyond the strictly written in one's name or in one's handwriting. The email notice that was also sufficient, as it held an electronic signature of the sender, of whom was the bank's attorney. In reference to the writ of possession and its 6-year period of enforcement, so with the writ of possession, you would have 6 years to enforce this. And Mr. Mitchell had argued that the bank was out of time. He argued this because the judgment, he was counting from the judgment that was given in April of 2014, when in fact the possession had to be counted from the date of the Court of Appeal judgment in 2018 and not the Supreme Court judgment in 2014. This 6-year limitation period would not have expired, as this would have been 1 day shy of 3 years. If there were to be an appeal to the Privy Council, then they would have to count from the date of the Privy Council judgment. So both the court and the bank confirmed that the precipice and the writ of possession were in standard and acceptable form, as it was drafted in accordance with the directions issued by the court by virtue of the memorandum of registrar of the Supreme Court of members of the Bar Association. If by any reason these documents were to be found to be incorrect, the court would have ensured to say that same would be remedied or corrected. Additionally, Mr. Mitchell had not alleged that, that they had suffered any prejudice as a result of these alleged irregularities. So Mr. Mitchell also tried to plead his case by referring to the Homeowners Protection Act. But this, even though this act was designed to provide meaningful protection for homeowners by ensuring a true and proper discourse between borrowers and financial institutions, this act could not be used, and it was not applicable because it came into force in 2017, but this case began in 2009. In reference to Mr. Mitchell's contending that the procedure adopted in executing the writ of possession had been flawed due to the non-service of the order for vacant possession, his claim was dismissed, as the bank made reference to his affidavit, where he admitted that several attempts were made to serve the order in July of 2020, and that it was in fact served in January of 2021. The bank further confirmed that both defendants were in court at the time of the possession judgment and they were in the court at the time that the possession judgment was delivered, and they were also provided with copies of same. The judgment also stated that they were present and fully aware. As a matter of fact, how could they not be aware, as the defendants filed and participated in an appeal on the same judgment? So he tried to appeal this judgment as well, but he said he didn't know nothing about it.
But he was there.
But he was there present to court, and still the judgment he said he didn't know about, he appealed to have it stayed again. So the bank's counsel stated that the application for leave to appeal the Privy Council was for nearly 3 years and should not be allowed to stall the bank's enforcement, as with many hopeless applications used to abuse the process of the court. So the bank's counsel, they got kind of tired of him just keep on trying to make delays on what's supposed to be done with them when the order was already made for their procedure to take place. He also asserted that even if the Mitchells were successful in their appeal to the Privy Council and awarded damages, would easily compensate them for any losses sustained by the result of a refusal of the application for the stay of proceedings. He also submitted that any consideration as to the defendants successfully appealing to the Privy Council would fall outside of the jurisdiction of this court that they were in now, and could only be considered by a court of appeal. It can only be considered by the Court of Appeal. The existing application of leave and stay of execution would have to be properly considered by a superior court. He also stated that the defendants had raised several allegations that were false and misleading and still do not warrant and any further judgment, as the court is now functus officio and lacks the jurisdiction to deal with any other issues presented. So, in conclusion, the court obviously ruled in favor of the bank. And even though the undertaking which the bank had previously given at the hearing of the matter on the 11th of February 2021, not to proceed with enforcement of the writ of possession until the determination of the application, that was now discharged. So their home was repossessed.
You see where they said that the judge said, in my judgment, the bank should not be deprived of the fruits
Right.
of the
So there was
judgment.
so much back and forth
Mhm.
in the situation.
Janine, you heard that, right? Janine.
Yes, ma'am.
Okay, so you ready now to tell her what happened next?
This happened before or next? I think this happened before, Okay, in the Court of Appeal, this was between Philip Mitchell and Finco. Of course, him and his wife appeared. They did not have an attorney. And Oscar Johnson, Tara Archer, and Mr. Audley Hanna appeared for Finco. Okay, he appealed their judgment for his complaints were that the judge was biased in their judgment and that the validity of the mortgage, it wasn't valid. And he argued that the terms of the mortgage cannot bind them. He also argued that the judge should have given relief under Section 3 of the Money Lending Act, as there were unaccounted sums in relation to appraisal, unlawful and excessive principal and interest assessments, and an indebtedness to applicants in the sum of $800,000.
Okay, go straight to the Money Lending Act, because we didn't cover a lot of him going back and forth for vacant possession, and he didn't win that one. What was his argument in the Court of Appeal when he was talking about this Money Lenders Act?
Okay.
Because even in this one, he started talking about the judge. Paragraph 29, page 21.
Okay, I still flipping.
Mm-hmm.
Okay, so
If you want, just go straight to the money lending. I go on to page 24. Because I don't know why in the world this man defended himself.
okay, so like I said before, he asserted that the judge should have given relief under Section 3 of the Money Lending Act. Section 3 of the Money Lending Act provides if proceedings are taken in any court by any person for the recovery of any money lent after the commencement of this act, or for the enforcement of any agreement or security made or taken after the commencement of this act in respect of money lent, and if there is evidence which satisfies the court that interest charged in respect of the sum actually lent in excessive, or that the amounts charged for expenses, inquiries, fines, bonus, premiums, renewals, or any other charges are excessive, and that in either case, the transaction is harsh and unconscionable, or is otherwise such that a court of equity would give relief. The court may reopen the transaction and take an account between the lender and the person used.
Sued.
Sued, notwithstanding any statement or settlement of account or any agreement purporting to close previous dealings and create a new obligation, reopen any account already taken between them, and relieve the person sued from payment of any sum in excess of the sum adjudged by the court to be fairly due in respect of such principal, interest, and charges as the court, having regard to risk and all the circumstances, may adjudge to be reasonable. If any such excess has been paid or allowed in account by the debtor, order the creditor to repay it. Set aside either wholly or in part, or review or alter any security given or agreement made in respect of money lent. If the lender has parted with the security, order him to indemnify the borrower or other person sued. Any court in which proceedings might be taken for the recovery of money lent by any person shall have and may, at the insistence of the borrower, surety, or other person liable, exercise the like power as may be exercised under the section. Where proceedings are taken for the recovery of money lent, and the court shall have power, notwithstanding any provision or agreement to the contrary, to entertain any application under this act by the borrower or surety or other person liable, notwithstanding that the time for repayment of the loan or any installment thereof may not have arrived. The foregoing provisions of this section shall apply to any transactions which, whatever its form may be, is substantially one of money lending. Nothing in this section shall be construed as derogating from the existing powers of jurisdiction of any court. Suffice to
So what the judge said?
It was incumbent on the applicants to show that the interest charge was excessive, or the amounts charged for expenses was excessive, or that the transactions were harsh and unconscionable, such as the equitable relief would be given. Instead, this claim by the appellant was unsupported by any evidence before Evans J. in the court below. And the applicants failed to establish a case for the application of Section 3 of the MLA.
Mm-hmm. And then he went on further. This man is saying about the computer printouts with the figures. Then he talked about the Conveyancing Law Property Act, Section 22, and that's when the judge had to put him in his place, where he explained what that means. A mortgagee shall not exercise the power of sale conferred by this act unless and until. So you can see in this instance, when he went back and forth before he finally ended up back to the Supreme Court again, he should have hired an attorney.
Yes. He even said that his wife didn't sign the document. It was forged.
Mm-hmm. Yeah, I don't understand. So he still ended up being outside catching COVID.
But Ms. Archer, even with an attorney, I don't even know if he had any grounds.
No.
May
But
not
I mean,
have sounded so crazy, yeah. Because you can't tell me he have it all. Something stopped somewhere.
but the court entertained him, and this cost us money.
It's crazy.
The court entertained. You see how long both of these are?
Yes.
Yeah.
Okay.
And he said that they only gave him the signature page to sign. They didn't give him the full document, but that was his attorney. That was for his attorney to do.
Yes, and that's why he was saying that it wasn't a valid document. I don't understand. But someone should have done it pro bono.
Yeah, he needed help because he was like, he don't know when the court did come in, because he could die first, or the wife could die first, or the court. Like,
and he was under economic duress.
Clearly.
wow.
It's a sad one.
Yeah.
Maybe that's why the wife didn't come to court.
I think she realized he missed a few screws.
Yeah. Mm-hmm.
He
Yeah.
tried though. He tried.
He tried. Right.
Yeah, he gave them a couple more years in the house.
I think it's paragraph 26. They say, in relation to the signing of the mortgage documents, the appellants say that Evans J. made an error in upholding the appellant's claim in circumstances being signed by or on behalf of FinCo. However, this proposition cannot withstand serious scrutiny. And the judge said, in the case of Vincent versus Primo Enterprises Voucher Sales Limited, Lord Denning dealt with the question of delivery of deeds in the following passage. He said, the law as to delivery of a deed is of ancient date, but it is reasonably clear. A deed is very different from a contract. On a contract for the sale of land, the contract is not binding on the parties until they have exchanged their parts. But with a deed, it is different. A deed is binding on the maker of it, even though the parts have not been exchanged, as long as it has been signed, sealed, and delivered. Delivery in this connection does not mean handed over to the other side. It means delivered in the old legal sense, namely, an act so as to evince an intention to be bound, even though the deed remains in the possession of the maker or his solicitor. He is bound by it if he has done some act evincing an intention to be bound, as by saying, I deliver this, my act and deed. He may, however, make the delivery conditional, in which case the deed is called an escrow, which becomes binding when the condition is fulfilled. He needed a lawyer. He really did. He really needed a lawyer. It's so sad. It really is sad. All right. Who's next? No silence.
I think that may be me.
Yes, it is.
All right, so I have Alan R. Crawford and Sharon Crawford, who are the plaintiffs, and Christopher Stubbs. Shannon's Cove Estate Company Limited, and Donna Dorset Major, who are the defendants, first, second, and third. So what we have here is that the Crawfords, being the plaintiffs and non-Bahamians, visited Cat Island and fell in love, and they wanted to purchase land. They were advised to purchase, they were advised that a Mr. Stubbs was looking to sell properties that he owned. He had 2 lots that he was interested in selling, and they, I guess, contacted him and agreed upon a purchase price for one of the lots, being, I guess, they were labeled A and B, but they decided on A. They were waterfront properties, and the price that was negotiated was $150,000. In agreeing on the price, they were, being non-Bahamians, Mr. Stubbs told them that, and not being familiar with Bahamian law, Mr. Stubbs advised them that his attorney can represent them in the transaction. And that is what they did. They reached out, and they were, I guess the attorney agreed to represent both parties. Now, the issue here is that in purchasing this property, they realized that it was, I would say, irregular when they went to have the meeting in order to sign the sales agreement. And then looking at the conveyance and everything, they saw where in the conveyance, the layout of the land, it was irregular. So they wanted the property a little bit more rectangular. And then seeing that, they proposed to have it, I would say, even out a bit more with the front, the back to be even out. So they, at the attorney's office, because they flew to Nassau to meet the attorney, they would have made changes to the plan at the lawyer's office. And the parties agreed, both Mr. Stubbs and the Crawfords agreed on the changes. Mr. Stubbs, being the first defendant, his, I guess, his part of it was that he would agree as long as they agreed to pay for the resurveying of the land, because it was smaller, for them to open it up an additional 15 feet from 60 at the back. I think it was 60 by 90. They wanted it to be 75 by 90 as it, and to correspond with the front. So in doing that, the Crawfords agreed to pay for the resurveying of it, and they paid Mr. Stubbs the $1,500 right then in order to have that done. And they asked the attorney, Ms. Major, to have the documents amended to reflect that, and they would have paid her the fees. Now, after they would have done all of that, Ms. Major would have sent them documents verifying the, I guess, the sales agreement and everything a few weeks later, showing where the changes would have been made on the sales agreement, and they would have signed it, and they also got a statement of the account, so they paid that as well. And they would have returned it to Miss Major along with payment for her services. Now, once they would have done that, because they agreed to with the changes that appeared, they figured it was okay to go ahead, and they started building their home, which was apparently their second home, vacation home here in Cat Island, I would say in the Bahamas. And they had a slight issue where, sorry for the noise. The layout of the property, the layout of the home, the contractor actually went about 5 feet over what the actual layout's supposed to be. I think it's supposed to be 6 feet back from the boundaries or something, and he actually went over it a bit or too close. So the Crawfords went ahead and they obtained approval and figured they were fine. So they weren't here when that would have been done. So that caused a bit of a challenge, because then Mr. Stubbs began causing or being a nuisance. And I would say, what is the right word I could use for you? I wouldn't say harass, but maybe that is a good word. The contractor and everything, whilst they were there doing their job, Mr. Crawford, whenever he visited, he said he didn't have any issues. So it seemed as if whenever Mr. Crawford is not there, that is when Mr. Stubbs would be a nuisance. Their issue with the whole matter is that after they would have built their home, Mr. Stubbs, because on the plan, when they would have made the changes, it was noted that there is a 15-foot access road that was supposed to remain there. That would have been a buffer between the two properties. That was supposed to remain a buffer and not be built upon or removed. It was to remain there in order to separate the two properties. Once they would have started building, Mr. Stubbs went ahead and he actually started building what's supposed to be a restaurant on that access road, which would have caused an issue. When I say an issue, it would have been a nuisance to the Crawfords and their home, because the property that they would have purchased would have been like a tract of land that was subdivided between, I guess, lot A and lot B. So by him subdividing this property, and that access road was supposed to have been used as, I guess, access to the beach. By him building on it, it would have restricted that easement for them to go to the beach and or to their property. Him building a restaurant or wanting to build a restaurant in itself also would have been a nuisance, because once it would have been erected, it would have created, I guess, an influx of traffic, customers, noise, and Crawfords would not have been able to enjoy their property as they would have intentionally purchased it for. So based on the rulings and the findings, the courts actually went ahead and they based on the evidence that the Crawfords would have presented, it was found and held that the information they provided was, I guess, more believable than what Mr. Stubbs was saying, because he in himself kept denying that he wasn't aware of the changes. He never agreed to the resurveying. The first time he would have seen it would have been when he was served a writ of summons. The attorney would have been negligent in representing both parties in the transaction. She stated that she was not, because she would have advised the Crawfords that they need an attorney for this transaction. However, she sent them a bill. She never advised them to sign the document stating that they are aware or they're not legal counsel. So in her, I would say, testimony, she was, I guess she lied under oath because her testimony wasn't completely truthful. She actually did represent them because she was quite aware that the changes were not correct when she sent them to be signed by the Crawfords and then recorded, the conveyance to be recorded. So in having that all done, and then because she actually sent the documents to be recorded, it was held that she very well did represent the Crawfords, because the attorney who represents the purchasers are responsible for having documents recorded. So she was actually found negligent in that instant for that matter. They also had where, Miss Archer, where am I falling short here?
I mean, this is roughly what happened. What did the judge decide?
The judge had there was an injunction that was filed.
Mm-hmm.
I don't, perpetual, pronounce the word, kia timet.
Mm-hmm.
Okay, so they had the need to show strong case of probability of apprehended mischief, right?
Right.
So whether the plaintiff established that an injury would ensue to them. So it would have been an injury to them because once the restaurant was there, they would have the vermins, the music playing at any hours. Then of course it was the matter of Mr. Stubbs building, I would say a cesspit right in front of their property out on the beach. So there was a possibility of that backing up, and I guess the scent from it or whatever, it would be that damage for them in terms of environment or scent in any event, the sewage. So accepting the evidence of the plaintiffs and finding, the parties did agree. It was held that they did agree to the handwritten amendments because they actually wrote the changes on the plan by hand. And when they actually started this purchase of the land.
Mm-hmm.
He, however, wanted them to do away with that and abide by what was this called? Because it was held that there was a case here that said whether it be I'm gonna tell you right now, whether it be by What is that word we always use? Clear demonstration. Okay. So the description of the property, I think is where it's what I'm saying, what I'm referring to, which said piece parcel, a lot of land has such proposition, shape, marks, boundaries, and dimensions that we always find in the hereditament. That in itself referred to whatever changes that the plaintiffs would have made on the conveyance. And they went back to Allen Reebely Building Limited v. Isley to try and support the case so that it can be held that the changes that they made versus what was on the conveyance originally, one, if it doesn't refer to one, it should be to the other, depending on if I'm saying this right. Am I saying that right, Ms. Archer?
Go ahead.
Go ahead. Okay, so it's where the if the verbal description is insufficient as by failing to indicate a boundary, the court may have recourse to the plan, even though it is by way of identification only. So what it means is that they would have to actually be looking at what is actually on the plan versus what is, I guess, what is said and changes that was made. So he held that they should do away, they should do a confirmatory conveyance to cure the misdescription which was made on the conveyance when they set out the sales agreement on August 30th. And in addition, the written description provided in the conveyance must be abandoned altogether. And the plan and the attached plan prevailed to reflect the dimensions as they wanted, which was 70 by 90. Okay, so outside of that, what they also looked at in depth was the matter of Mr. Stubbs being non-cooperative. They had tried to reach him on numerous occasions, wanting him to actually cease and desist building the proposed restaurant. He would have, I would say, been very rude to both the court appointed, what do we call that person? Okay. Pardon?
When you say court appointed, who are you referring to?
There was, I would say, somebody was sent by the court in order to actually have a look at the building that, pardon?
The surveyor?
No, the surveyor was actually Mr. Stubbs' surveyor. So he was acting on instructions by Mr. Stubbs. And no, the person that actually went to view the land itself was sent by the court. And they would have actually provided their evidence or their statement and said that Mr. Stubbs was very rude even upon their visit. They would have noticed how he would have, I would say, went on to the Crawford's land to point out the actual markers for the property. And he went on their property and pull up a plan off their property, noting that it's not his property, it's theirs. So they would have been able to actually state that in their testimonies, saying that he's very rude and non-cooperative or uncooperative in trying to resolve the matter, as opposed to having a lengthy litigation going on. They were trying to actually resolve it. GSO was trying to resolve it between, well, all of the defendants and the plaintiffs.
So we do know that Mr. What's his name is? Mr. Stubbs appealed.
Mr. Stubbs appealed.
Mm-hmm.
Yes, he did.
He appealed this decision.
He appealed the decision.
Yes, he did. Who's supposed to do the appeal?
Who's supposed to do which appeal? Mr. Stubbs' appeal?
Hmm.
Miss Major?
No. We actually, I sent another case, which was the appeal.
Oh, I didn't do that one, Miss Archer.
No, someone else was supposed to do that, but she's not on.
Oh, okay. I thought you heard my heart just now.
Appeal that decision.
Yeah. Because the Crawfords actually, they were seeking costs.
Mm-hmm. So this is when he appealed. This is what the judge said. The judge said he looked at what the trial judge did in the first instance, right? And he said that at the time when he was in the Supreme Court, he said Mr. Stubbs was found not to be a credible witness.
He's not a credible witness.
Right. And so here he is now. He's going to quote from Indira Charles. Said at various times during cross-examination, Mr. Stubbs was inconsistent. He alleged that he never met with the Crawfords at Mrs. Major's office. He said that he did meet the Crawfords in Mrs. Major's office. He stated that he did not arrange for the original survey plan to be prepared. Then, further down, he said that he did arrange for this to be prepared, although he alleged that his instructions were not followed. So notwithstanding a paragraph 8 of his witness statement where he averred that under the first 60 by 90 plan, provision was made for beach access between the Crawford's property and his property, during cross-examination, he insisted that he never instructed the surveyor to show an access road on the original plan, and the surveyor had shown it on the plan for reasons unknown to him.
Mm-hmm.
He had never seen the plan and drawn changes on it before the writ was served on him several years later. Subsequently, he said that he might have seen a plan at Mrs. Major's office, but he could not say what plan he saw if he saw one. He agreed in Mrs. Major's office to have a new survey plan prepared showing the property with even dimensions of 75 by 90, conditional upon the Crawfords paying the cost, and that the Crawfords paid the cost then and there.
Mm-hmm.
That he only ever had one survey plan prepared and knew nothing of the plan that the quote-unquote new survey plan was to replace.
Right.
He did not have a new survey plan prepared after the Crawfords paid him the $1,500 in Mrs. May's office. And then at pages 59 and 60, he said that he did have a new survey plan prepared, although once again the surveyor, unlicensed, mysteriously inserted an access road without any instructions from him. He said, and then, having had the opportunity to observe the witnesses as they testified, this the judge is saying, I found Mr. Stubbs to be an unimpressive and inherently unreliable witness. With respect to Mrs. Major, I found some parts of her evidence to be reliable and other parts not to be. I did not believe when she testified that she did not represent the Crawfords. I still return to the issue momentarily. In my opinion, only one party has ever had survey plans of the property which was sold to the Crawfords, and that was Mr. Stubbs. I found that both plans were not prepared at the behest of Mr. Stubbs and his surveyor. That both plans were prepared at the behest of Mr. Stubbs and his surveyor, did not miraculously insert an access road on two separate plans without Mr. Stubbs' instructions. Despite his denials, Mr. Stubbs clearly instructed his surveyor to draw the original plan showing the property with its northeastern boundary only 60 feet long and an access road running along the southeastern boundary. Later, Mr. Stubbs instructed his surveyor to amend that plan and increase the length of the northeastern boundary to 75 feet without otherwise disturbing the access road. The prepared plans state that they were prepared at the instance of Mr. Stubbs. Further, with respect to the plan, Mrs. Major contradicted Mr. Stubbs' evidence. She said Mr. Stubbs brought that plan to her office on the 30th of August, 2010. It was marked up in her office in her presence. The markings reflected the change for the additional 15 feet. This corresponded with the Crawford's evidence on this point and contradicted that of Mr. Stubbs, that he had never seen that plan before it was served on him at the commencement of the proceedings. You see how they give the Bahamas a bad name?
Very much so.
Yes.
And the Crawfords, they really didn't want, it wasn't the issue that they didn't want to have him do anything on his property. It was just that he was building on the access road that they had agreed on, that there wouldn't be any buildings on.
Mm-hmm.
And they kept switching their story because Ms. Major very well knows that she was representing both parties.
Well, at least she was sued for negligence.
Yep.
Yeah. So Mr. Stubbs appeared to have developed a personal animosity towards the Crawford.
Yeah.
And a desire to remain the boss in Shanna's Cove. His former position as administrator of the island seemed to have gone to his head, giving him false aspirations. His desire to bend the Crawfords and the other residents of Shanna's Cove to his self-control was further exacerbated when the court visited the locus in quo. On that visit, when the court asked Mr. Stubbs a question about the location of the survey pins, he marched onto the Crawford's property, laid hold of a mature plant that was near one of his recently installed survey pins, and wrenched it from the ground. He did so without permission and without thought or care for whose land he was on or whose shrubbery he was destroying. In the words of Mr. Sweeting, there could hardly be a clearer demonstration of his imperious bullying attitude or the accuracy of the claims against him. In addition, I believe Mr. Crawford when he testified that Mr. Stubbs had threatened his life and the safety of his wife and his dog. He said that Mr. Stubbs has also threatened to bring a bulldozer to demolish their house, and has stated that no judge in the Bahamas can tell him what he can or cannot do with his property. This is indeed unfortunate language coming from a man who once held the prestigious position of administrator of Cat Island. All things considered, I prefer the evidence adduced by the Crawfords to that of Mr. Stubbs and Mrs. Major. I find as a fact that Mr. Stubbs agreed that the 15-foot access road that divided the two lots was to remain unobstructed. And he lost.
Yep.
They asked him to remove the septic tank.
Mm-hmm.
This is, I mean, he's a disgrace.
He owns Cat Island.
Apparently so. He even rules the court.
Apparently so. He makes the decisions.
Apparently so. That's what he's saying. That is what he said. He is in charge.
HNIC.
That's right. To rule the world, you all have to be careful. No, it's when you consider to a foreigner and a foreigner spending their money. Where you getting this attitude from?
Mm-hmm.
Anybody else have any cases? No? I'll leave this other one for next week. We'll do Finco and Teresita Johnson next week.
Okay.
We'll leave that one. All right, so let's go to module 4. Did you enjoy the cases?
Yes, very interesting.
Very interesting. You don't have any shorter ones, eh?
Well, the one on Finco and Teresita Johnson is short.
Okay.
That one is only 10 pages.
10 pages, yeah, I remember seeing that.
And it's big print. Yeah. Let me see, the ones for next week may not be that long. A lot of them will just be summaries that you can get on the internet. I'll assign those at the end. So now we're getting to the good part. What happened? The good part. Unit 4, module 4, mortgage over land. So we know the borrower who grants the mortgage over the land is known as the mortgagor. The lender is known as the mortgagee. So when the loan is repaid and the land becomes free of the mortgage again, the mortgagor is said to redeem the land. During the currency of the mortgagor's residual rights in the land is known as the equity of redemption, or just simply equity. Its value is the value of his unencumbered collateral minus the value of the secured loan. You understand that? The equity of redemption.
Yeah.
Okay. So a mortgage implies the transfer of the mortgagor's interest in the property as security with the proviso for the transfer on satisfaction of that obligation. A charge implies a mere right to look to the charge's property to satisfy an obligation without such transfer. Because we spoke about a charge before versus an actual mortgage. So when a discussion of security is raised, there are two distinct issues. What is the nature of the interest in the land or collateral? That is the subject matter of the security. For example, the mortgagor may have a freehold or leasehold estate in the land, and its interest may be legal or equitable. Also, the land may be unregistered. The nature of the security interest created must be ascertained. That is, legal or equitable mortgage or charge. When a secured loan is obtained in relation to a mortgage, the borrower gives the lender an interest over the land, a right in priority to other creditors, and the power to obtain repayment of the loan and any interest due through numerous legal remedies, including but not limited to power of sale if the borrower defaults. Enforcement of the mortgagee's rights through establishing actionable legal remedies is a fundamental premise of the law relating to mortgages. For example, even though the mortgagee must obtain a court order in order to effectuate a power of sale, the power of sale does not make the mortgagee the legal owner of the land. The mortgagee is merely exercising his right to dispose of the land by sale so that it may repay itself what it owes under the mortgage loan. However, it should be noted that any surplus obtained in the sale of the mortgage property belongs to the mortgagor, subject to the rights of other mortgagees to whom the mortgagor may have given subsequent mortgages of the same security. Now, equity of redemption. The mortgage loan is a contract under which the mortgagor offers a legal interest or mortgage over the land in return for an amount, which the mortgagee loans to him and under which both parties undertake to carry out certain legal obligations. Consequently, the mortgage acts as a security for the mortgagor's due performance of the contract. Once the mortgagor performs his obligations under the terms of the contract, his land is released from the mortgagee's rights or legal interest in the land and freed from his personal obligation to the mortgagee. If the mortgagor fails to discharge his obligations under the mortgage loan, then he's actually in breach of contract and may no longer retain his contractual right to redeem. So, under the equitable principle of equity of redemption, the mortgagor has the right at any time after the contractual date of repayment to pay the loan and redeem his security. He must give notice of repayment or pay the interest on the mortgage loan. So this is where sometimes I know a lot of, in my last class, a lot of students who were not in the banking business, but they were actually in the process or wanting to know how a mortgage operates. And they had a lot of discussions about making personal payments, because they said they know when you get a mortgage for 15 years, 20 years, 25 years, but they didn't want it for that duration. And they wanted to know how they can go about making lump sum payments. And I told them that's a discussion that they need to make prior to that mortgage document being made up. Because once the bank grants a mortgage, the interest is already calculated for that duration. And if you're cutting it short, then the bank is going to lose money. Y'all have any thoughts on that? So although
Ms. Archer,
go ahead.
what you're saying is that principal repayments, early repayments should be something that a client finds out prior to signing their mortgage documents?
Yeah, like I was saying, these students, they weren't just going in for a mortgage. They wanted to know how does the bank operate? Because they'd heard a lot about houses going up for sale, and they couldn't understand how that happens. So they wanted to learn how it happens. What does that mean? And then they asked, well, why can't you make principal payments? Not all institutions allow you to go in every month and make principal payments. So instead of it being a mortgage for 20 years, you cut it down to 10 years.
Okay.
So though in a loan financing, the equity or the equity of redemption in relation to the mortgage is the value of the land, which is the difference between the amount originally borrowed and the amount presently owed to the mortgagee. In strict legal terms, the equity of redemption is the general rights of the mortgagor to redeem his security and discharge the mortgage or legal interest of the mortgagee over his land by repayment of the mortgage loan. Of course, after giving notice of his intention to repay and paying the agreed amount of interest. So the equity of redemption also represents the mortgagor's remaining interest in the mortgage land while the mortgage exists. So a lot of people, while things were going good, they would have actually borrowed against the equity of redemption, getting further charges. So when you speak about clogs on equity, what does that mean? It means that there must be no impediment on the equity of redemption. So let's say someone has a mortgage for $50,000 and they've paid back so far $20,000. So the balance is $30,000. What it's saying to you is that that person can come in and say, guess what? I paid down $20,000 and I want another loan using the same security. So you could give them advice and say, Well, I don't think that's a good decision based on whatever reasons. But if they can qualify for it, the law says, under common law, that you cannot clog the equity of redemption. In principle, the borrower ought to be able to get his property back by paying off the loan with his property in the original condition. The borrower should not place undue postponement of redemption. Note that the parties may agree to a long-term repayment, and early repayment might put the lender at a serious disadvantage. And that's what I was just talking about. In terms of paying it off early, it will put the bank at a disadvantage. So under English common law, upon which, of course, the Bahamian Mortgage and Land Law is based generally, and the Conveyancing and Law of Property Act, they require the recording and filing of the relevant mortgage document and conveyance after the production of evidence of the payment of stamp duty. The legal requirement is necessary to perfect and protect the security interests of the relevant party to whom the property is mortgaged against third parties generally, without proof or specific notice to any particular claimant or any actual knowledge on its part of the prior interest. So in addition to the foregoing legal principle, a security interest, which is unrecorded or filed in the absence of a statutory provision to the contrary, may be perfected vis-a-vis a particular third party by notice to that party or by knowledge on his part. In general, an accurate and thorough title search of the particular property being mortgaged or used as security for a mortgage will assist the prospective third-party purchaser or creditor in discovering the existence of an adverse title or security interest, whether created by a prospective seller, a debtor, or one of his predecessors in title. The object of filing or lodging the mortgage document or other documents of title in support of the mortgage is to give notice of the security interest to third parties. Although failure to file or lodge the relevant mortgage document does not affect the enforceability of the security against the debtor himself, the time of filing of the documents is of utmost importance in terms of the priority of interest of the secured creditor. It's important to note that in terms of the priority of security interests, particularly as it relates to mortgages in the Bahamas, the first document to be recorded in time prevails. And that's based on common law principle. The first in time prevails. It has nothing to do with the execution or the creation of the document. It's who records it first. Failure to file or lodge a security interest, whether a mortgage or a judgment order from the courts, will result in the fact that secured creditor is postponed or subsequent encumbrances and loses out altogether to an outright purchaser, particularly a bona fide purchaser for value with no knowledge of the prior security and one who is not involved in any fraud or collusion regarding the same. It should be noted that where the mortgage property is a debt or other money owing as the person whom the notice should be given, a mortgagee who gives written notice to the debtor gains priority over a mortgagee early in date who omits to give notice. The omission to give effective notice leaves the property under the mortgager's control and deprives the second mortgagee of the chance of ascertaining the existence of the first mortgage by inquiry of the debtor. The filing of the relevant mortgage is important to the notice requirement and to protect the interests of the first mortgagee because the priority of the second mortgagee does not depend on whether it made inquiry. It depends solely on notice. A judgment creditor who obtains a charging or similar order from the court will be treated as a volunteer and cannot gain priority by giving notice. Where notices are contemporaneous The encumbrances will rank in order of the time of creation. So with regard to priority enforceability of real property taxes as a lien on a subject mortgage, after filing of the mortgage document, it should be reiterated that real property taxes represent a first charge over property, which arises automatically by operation of law, and it doesn't require any filing or lodging by the appropriate government agency responsible for the assessment and the collection of taxes. It's automatic. So whenever you're going to purchase a property, whenever you're going to sell a piece of property, if you're going to a bank for a mortgage, the very, very first thing is real property tax. And you know, a lot of people were making, I guess they were questioning the government's authority to assess the property. In the actual act, it says that real property taxes can be assessed for 10 years retroactively. The first charge ranks in priority to the mortgage security interest filed and created by the mortgagee, and is better understood in the context of the legal obligation and the liability of mortgagees as they relate to the payment of real property tax on the mortgage property, since those mortgagees will be deemed to be owners of the property where real property taxes remain unpaid, particularly during the mortgage currency. So what are the remedies of a legal mortgagee? As a lender, the bank will have the usual right to bring a personal action against the debtor on his promise to pay. So the first remedy that the mortgagee has is an action for debt. The mortgagee has a right to sue on the debt independently of the security if it wishes or decides to do so, particularly where the proceeds of the sale of the mortgage property are less than the amount still owed under the mortgage loan after default. However, banks' rights as a holder of a security interest are more extensive and are important if the debtor becomes insolvent. The remedies depend on the nature of the security, and that is whether it is a legal or equitable charge or whether the security was effected by deed. So the remedies that are available to a mortgagee on default of the mortgage loan by the mortgagor are, after action for debt, is entering into possession. A court order is required by the mortgagee in order to enter into possession. If the mortgagor is in occupation of the mortgage property, the eviction order is needed. The costs to enter into possession are borne by the mortgagee. Entering into possession is normally one of the initial steps in selling the mortgage property by exercising the power of sale. There are a number of restrictions on the bank being able to enter into possession. If the mortgage property is a dwelling house, then the court has a discretion to adjourn the action if the mortgagor is likely to be able, within a reasonable time or period, to pay. In the case of Cornell versus Maltby, it suggests that there is general discretion in court to use possession to a mortgagee if possession is not sought for the purposes of enforcing security, but for an ulterior purpose. The third remedy is appointment of a receiver. Where mortgage property is leased to tenants, the receiver appointed by the mortgagee is paid rent directly by the tenants of the property, rather than pay such rent to the mortgagor, who is the landlord. Now, this is an attractive remedy only if the bank wishes to continue with the mortgage and the land is income producing. However, before the bank mortgagee appoints a receiver, it must make formal demand for repayment from the customer or mortgagee. There are some extensive cases setting out the duties of a receiver, one which you will read. Sylvan Properties versus Royal Bank of Scotland. Although the receiver is appointed as an agent of the mortgagor, he must take steps to protect and preserve the mortgage property. When it comes to selling the property, they owe the same duties to the mortgagor and others interested in the equity of redemption. This means that although they must obtain the best price reasonably obtainable, they are not obliged to take steps to enhance the value of the property or to delay a sale in order to achieve a higher price. The remedies of entry into possession and the appointment of a receiver do not bring the mortgage to an end. The sale of the property. The Act gives the mortgagee a statutory power of sale once it becomes clear that the mortgagor is likely to remain in default of his obligations. Banks normally seek this remedy in conjunction with obtaining vacant possession. Under the terms of the mortgage loan, the mortgagee has a power of sale to sell the mortgage property in the event that the mortgagor defaults, even where the property is still occupied by the mortgagor, subject to obtaining an eviction order for eviction and following other legal formalities. In the case of Sylvan Properties, again, versus the Royal Bank of Scotland, it says a mortgagee is not a trustee of the power of sale for the mortgagor. In particular, the mortgagee need only have regard to his own interests and need not postpone the sale in the hope of obtaining a higher price or take steps to achieve a higher price. The mortgagee's only duty is preserving the value of the security and to obtain the best price that can reasonably be obtained. And you'll see this when we begin to go over the cases in the next class. As previously mentioned, if a mortgagee exercises his power of sale and there are surplus proceeds from the sale, that is, the net sales proceeds exceed the amount due from the borrower, those surplus proceeds must be paid to the mortgagor. Once on the realization of security, the bank must act reasonably and obtain a fair price for the mortgage property to be sold under power of sale. And the case for that was Standard Chartered Bank versus Walker and Walker. An appraiser or surveyor who negligently values a house for mortgage purposes so that its for sale value is less than the amount loaned by the mortgagee to the mortgagor will be liable to pay damages for the mortgagee's entire loss, including any unpaid interest at the default rate in the mortgage loan. The next rule is the timing for the realization of security or exercise of the power of sale after default is entirely a matter for the bank. The bank is not liable to the mortgagor or surety for a decline in the value of the mortgage property unless the bank was responsible for that decline. And the case for that was China and South Sea Bank versus Tan Son Jing. The decision of the court was that a mortgagee's decision on sale is not constrained by the reason of the fact that the exercise or non-exercise of the power will occasion loss or damage to the mortgagor. He can sit back and do nothing. He is not obliged to take steps to realize his security. Where a creditor has concurrent remedies against the debtor, a security and a surety, it is a matter for him which one he pursues, if indeed he pursues any at all. Again, in the case of Sylvan Properties Limited, and in the case of Chad Enterprises Incorporated versus the Royal Bank of Scotland, in this case, the court held that by accepting office as receivers of the claimant's properties, the receivers assumed a fiduciary duty of care to the bank. The claimants and all, if any, others interested in the equity of redemption. The scope or content of the duty depends on the special nature of the relationship between the bank, the claimant, and the receivers, arising under the terms of the mortgages and the appointments of the receivers. And in particular, the role of the receivers in securing repayment of the secured debt and the primacy of the obligations in this regard to the bank. That was inconsistent with the duty to take the pre-marketing steps for which the claimants contended in this action. It should be noted that a court has the power to order the sale of mortgage property, even though a mortgagee may refuse consent to the sale, because the sale would realize insufficient funds to pay off the money advanced by the bank for the mortgage loan. In the case of Polk versus Mortgage Services Funding PLC, the court ordered the sale sought by the mortgagor, refusing to let the mortgagee retain the property and rent it out. The value of the property was insufficient to cover the loan, and the rent would not cover the interest payable, with the result that the mortgagor's liability would increase if the mortgagee remained in possession unless property values increased steeply. Under decision in Target Homes Loans versus Clothier, a bank may allow a mortgagor the opportunity to try to sell the mortgage property, as the court held the view that there may be instances where an occupied property is more attractive than a repossessed property. The terms of the sale of the mortgage property by the mortgagor already in default may also be agreed that after the end of a certain period of time, say 3 months, and no sale was made of the property, the mortgagee could take immediate possession of the property, subject to the legal formalities, and exercise its power of sale. Additionally, a bank, in exercising its power of sale, has no duty towards a beneficiary of a trust, where the mortgagor is a trustee of the trust or mortgage property. And the last remedy that a bank has is foreclosure. Under court order, which must be obtained by the mortgagee, ownership of the property is transferred from the mortgagor to the mortgagee. Any questions? This will come clearer as we read the cases next week, when a bank is exercising its power of sale. And then we'll also look at Sylvan Properties for when there is a receiver. So you can see what the responsibilities, because you could have instances where there is property that is income producing, and you have to know what to do and what are the obligations of the receiver in carrying out their duties. And you would follow the case of Sylvan Properties. So now, let's see. Who wants to do Sylvan? Always on the exam. No takers?
Gosh, I scared to go first because last time I get a whole 40-page assignment.
Oh no, Stubbs, Crawford and Stubbs is 40 as well, 44 actually. I almost scared to go last.
Jeez. What am I hearing? What am I hearing? You're supposed to be, no, okay. I'm looking at the ones for remedies now. Then I'm going to pull the local ones. The local ones is where you have long pages, I think. Who's going to do Sylvan? No, Sylvan is a good case. Everybody must read it because it has to do with receivers. Sylvan, and I need someone to do Cornell versus Maltby.
I guess I'll take Sylvan.
Dora May will take Sylvan.
Mhm.
Okay, who's going to take Cornell?
I'll take on now.
Okay. See how easy that was? That wasn't hard.
No, the problem is we don't get these cases until Friday.
No, I'm going to tell, no, Mr. Pratt he had hit it and it went into draft. He thought it was gone. When I called him, he apologized.
Okay.
Yeah.
Mhm.
It won't happen this time because what I'll do is I'll keep on him. When I send it, I will tell him, make sure that it's gone. Okay, let me see. What else do I have here? L versus Maltby. Hold on, I'm gonna look for my Bahamian cases. Where did they disappear to? I have them by the stock. So look, I'm gonna have to assign them when I hang up. I have quite a bit. Okay, I'll assign those afterwards. Let me see which one is this one here. I think this, I'm trying to see if this one isn't too long. This one is 19 pages.
I can take that one, whichever that is.
This is Evelyn Firth, Frith. That's Janique.
Yes, ma'am.
Okay, so that's Evelyn Firth versus Scotiabank.
I have a question. Most of the exam will be case studies. We have to actually try and remember most of these case studies, these cases.
I remember. What do you mean?
Okay, we're going through these. So you're gonna put a question on the exam about Evelyn Firth versus
No.
Scotiabank. You're gonna ask us to answer something on it, or?
No, you won't see any names of any cases. Only way you'll see names on cases, don't forget now you are wanting multiple choice for
I
midterm.
was just gonna say this is gonna be multiple choice, true or false.
Who? True? No. You want true and false too?
Yeah.
Oh my God.
No.
No, stick with the multiple choice.
For the final, you'll have multiple choice and short answer. Now, maybe in a short answer, I may give you a name of a case,
Okay.
but I will tell you that when we do the review. So let's just say now, when we go through these cases, let's take the remedies. So you know that there are 5 remedies that a bank can take. So I could actually give you a multiple choice question based on what are the steps a receiver would take, or what is expected of a receiver. And that will come from the case of Sylvan. So the question say Sylvan. It may say something about a receiver. The bank has appointed a receiver. Which one of the following is not a step that the bank or that the receiver should do? Or what is the expectation of the bank of the receiver? And then list 3 or 4 options. So they're just general principles. Getting clearer?
Yes, ma'am.
Okay. And so let's take the one of those we did tonight on the lawyer representing both parties. The judge had quite a bit to say about that. Remember?
A lot.
Yeah, she had a lot. So I could read all of that and I could come up with maybe 2 questions, maybe 1. On negligence, what is expected when a lawyer represents both parties? Then I could give you a question on condominiums. Because all of these are cases that you should have read. And then I'll throw in some easy ones. Straight from the chapters, from the units.
Sasha, do you have an idea of how many questions we'll have on this midterm?
No, I haven't written it yet.
I was being hopeful. Okay.
But you don't want it to be that short. What you think? How many?
I don't know. I was hoping you would already, had an idea. So,
Oh no, I start writing.
okay.
So there won't be 100. I mean,
No. I was thinking more 20, 30 questions.
yeah, that's 30. If I multiply by 2, that's each one gets 2 points. That's 60. So do you want a couple of short answers?
Not midterm.
Okay. I hear you. I hear y'all very well. Not midterm, just for the final. Okay. All right, I gotta look for some more cases. And so when I send the email, I will assign. So I have Dora May, I have Demetra, I have Janique. So Janine and Zena and who else? Yeah. I'll assign you all some local cases. So hopefully I put those together and then let Mr. Pratt send them out to you. But those who are doing Sylvan, you can find that online, and Cornell is online.
Okay.
All right. So let me
Yes,
look for this now so I could get them ready for Mr. Pratt to send to you all. And we could have some fun reading these people's life stories. Okay, so I have that one. All right, let me get some cases together. All right, then. Have a great evening.
you too.
You too.
Good night, everyone.
Good night.
Night.
Good night.
Yeah, make sure you get it before the holiday weekend, okay?
Oh, yeah. Okay, so
Yeah.
class is on Tuesday, right?
Yes.
All right.
Okay. All right. Good night.
Good night.
Good night.